Good afternoon. I'm Rudy Canizares, your treasurer, your host for today's Regulatory Hour webinar. As always, FSBPT is fortunate to have Dale Atkinson on an ongoing basis. Briefly highlighting Dale's background, Dale received his law degree from Northwestern School of Law, Portland, Oregon. He also represents various associations of regulatory boards. Just a couple of reminders. Dale prefers questions on the fly, so please don't hesitate putting in your questions in the chat. I will make sure Dale and I will monitor that. If somebody has a compelling desire to ask a question for Dale, feel free to raise your hand and we will acknowledge you. Just as a reminder, the next Regulatory Hour webinar is on July 13th, Wednesday at 4 p.m. Eastern Daylight Time. The topic is July jurisdiction. So I'm pleased to have Dale present today's Regulatory Hour topic, Give Me That License. Dale Atkinson will discuss Mandamus, a judicial remedy requiring a government body to act or not to act. All right, Dale, it's all yours. Thank you.
Rugi, thank you so much, and hopefully you all can hear me. Welcome back to those that have been regular attendees, and an extra special welcome to perhaps some of our first-time attendees to these regulatory hours, and also a welcome to a continuation of the year 2022, the year of alliteration, and we are in May Mandamus in this, and so we will continue on with that. Hopefully that brings us at least a chuckle or smile to some of your faces, as we want to be as entertaining as well as we provide the content. So the way I start, let me make sure I can advance my slides. Sorry about that. I do want to give a big sincere thank you. I start all my presentations this way, and so thank you to FSBPT, its board of directors and staff and leadership, for allowing these regulatory hours to be established and put on. The biggest thanks goes to each and every one of you who are on the line today. Many of you are, I know, volunteer board members, perhaps staff, executive directors, administrators, assistant AGs, and inspectors or investigators. And you all deserve a big thank you for what you do for public protection. You're not thanked enough, and I think the regulatory community is under a lot of scrutiny. And you deserve these thanks. Part of the reason that FSBPT puts on these seminars is to provide content to you, so when the scrutiny or the heat starts, getting to the regulatory community, we are all much better prepared, hopefully, to address situations that might arise. So a big thank you to each and every one of you. As Rugi mentioned, we do want you to participate. So if you've got something to say and you want to unmute, feel free to do that. And I'll keep an eye on the chats as well. But if you do have a question, chat it in or unmute and speak up. And we'll do the best we can to keep an eye on things. This is how adults learn best. And today's session, especially, by the way, it's important to participate because there'll be several slides where I will ask some questions and seek the input from each and every one of you. So, as is customary for those that have been attending, there's usually a picture of some celebrity or somebody else, and I have to identify that's not really me. Very quickly, I am Dale Atkinson. As mentioned, I'm an attorney, and I represent a whole bunch of FSBPT-like organizations. So you are not alone as a regulator. Your organization is not alone as an association or federation of regulatory boards. So take advantage of that. So feel free to chat in. I want to make sure you all know how to use the chat and you're actually listening and watching. And so do you all think that's me, Rich, or maybe neither one of us that's diving off of this bridge here? So we got some neithers, we've got some ones and twos. Perhaps if I remember, I'll reveal who that really is sometime throughout this session as well. And while we're at it, before I did that other session or the other slide, I go ahead and type in here whether you'd rather have ice cream or cake. So this is to make sure you guys are listening and paying attention. And this will again encourage you to participate in these. So May Mandamus, the topic for this month, and a mandamus is really a fancy way of just saying it's a judicial remedy in the form of an order from a court to a government entity to do or not do some specific act that the body is alleged to be obligated to do. And the case we're going to use today is actually a mandamus proceeding attempting to set aside a disciplinary action, an adverse action. But you could see mandamus come up in many, many other circumstances. And so everybody knows that one, we use the mandamus to get our alliteration theme, continue our alliteration theme through 2022. And it may not be called mandamus in your jurisdictions, but the ultimate outcome is the same. It's somebody who is challenging the regulatory board itself and seeking some remedy that they believe they're entitled to. So, if anybody wants to chat in when you might think a mandamus, you might see a mandamus proceeding. I will give you one of the answers, and that is in a disciplinary setting. And so, and I see a chat in here. Do you have to jump off the bridge for the cake? Yes, you do. So that is true. No ice cream, but you get the cake if you jump off the bridge. So when might you see a mandamus proceeding, or whatever it might be called in your jurisdiction, other than an appeal, if you will, or a challenge to an adverse action, a disciplinary enforcement administrative proceeding? And so feel free to chat in when you think you might see one of those or be exposed to it. And when I say as a board member or staff meeting, it comes before the board and ultimately will be resolved in one way or another. And so the chats are a little bit quiet now. So where you might see them, or where you most often would see them, is seeking the issuance of a license. So for instance, one example I can think of off the top of my head would be, I'm a foreign educated, applicant for licensure. I think I meet the requirements of licensure, and that you are refusing to issue that license. So therefore, I am going to file a mandamus proceeding seeking a court to order you as a board to issue me my license. That could be for renewals. It could be for reinstatement. As I've mentioned, it could be to set aside an action of the board. And I use foreign trained in my first example on this slide is just because it's more likely that question may be debatable about whether the education is sufficient or equivalent to that in an accredited program in the U.S. Understanding you all have your program as well that FSBPT participates in. But so these are some examples. On one of my very last slides, one of the examples I will use is under open records, and I probably should have put it on this slide. That's probably a very common theme to seek a mandamus proceeding, to say turn over documents that are subject to being disclosed under an open records request or Freedom of Information Act request. And so it's a fancy term, but it also is intended to identify probably some things and some issues that all of you on the line have been exposed to or will be. So I see a chat here too about not issuing a license due to a criminal record of some type. And so that would be an excellent example too of a challenge where there's discretion in the board, subjective, if you will, decision-making as to whether one has, let's say, good moral character. And criminal background checks are a really good example of that. While we're on that topic of criminal background checks, and having spoken on this topic a lot lately because these questions are arising, is good moral character. And so just a little side note, unrelated to the topic of mandamus, but that is the movement in the United States jurisdictions to either remove good moral character from a prerequisite to licensure or limit the scope of what a board may consider as a basis to perhaps not grant or deny that licensure application. Just probably 2 or 3 weeks ago, the governor of Arizona signed into law a prohibition. I shouldn't call it a prohibition. They remove good moral character from the assessments of all licensing boards in the state of Arizona. So good moral character is no longer a subjective requirement that the boards are able to look at, and I believe it applies to all the boards, including the physical therapy board. So we all are keeping kind of an eye on this issue of subjectivity, good moral character, and where that might play out. So it's a great example. It's a good question there, and it certainly plays into our topic of a mandamus proceedings to say, issue me a license because I qualify for it versus the board perhaps thinking that I don't qualify for it. So we are going to use this Walker case. It's a couple years old, but it's a really interesting case because there's a lot of issues that surface. There's a lot of facts that I think everyone on the line will find to be interesting. And these facts, I think, then help create some of the issues and questions that need to be answered. You guys get paid all that money to volunteer to serve on your boards to make these kinds of tough decisions. And hopefully somebody chuckled on that. And this is related to a challenge to an adverse action or disciplinary or enforcement action undertaken by the Physical Therapy Board of California. And so let's get into a little bit about the facts themselves. And so each and every one of you, I do a ton of board member training for my clients. And it's really all about issue identification. It's not about answers. And so as we go through these facts, you all can start to digest what you think the important issues are and how it comes into play within your jurisdiction. We are dealing with a case with a person who is already licensed. So it's not an issuance issue, but it might be a potential removal of that license or an adverse action or sanction entered against it. But you all should start identifying the issues and how they might play out within your jurisdiction. And many, many of those issues and questions will be determined by what your statute says, the very specific language in the statute, which is why language is so important. And it's so important for all of us as we read the statutes or rules or regulations or even your policies that we learn to identify what are important issues that may surface. So we have a physical therapist who allegedly is under the influence of alcohol, driving to pick up dinner and clipped a parked car. This physical therapist stopped the car, backed up, and ran into another car. Again, to assess, I guess this physical therapist was assessing, what damage they may have done. And she left the scene after clipping both of these cars. No one was hurt. There's only property damage. There's no, injury to any individuals. There was a neighbor walking her dog that saw all of this happen. And the neighbor eventually then called the police and reported this so-called hit and run to the police. The physical therapist, in the meantime, continued to the restaurant while waiting for the dinner to be prepared, had wine, and it's in dispute as to how much wine, but we'll get to that in a minute. Eventually, the dinner was prepared, ready, and the physical therapist drove home. So let's just assume everything in here is true so far. And we're going to ask ourselves a question about, well, one is operating a vehicle under the influence a relevant factor to a physical therapist? And should that be grounds for at least an investigation, assuming there's a complaint filed, an investigation and perhaps an adverse action? So we start to think about that in and of itself without the police being involved yet. Okay, so start to digest that. Think about how that might come into play in your jurisdiction. Well, the physical therapist got home, and the police came to the home and knocked on the door, observed the physical therapist was unsteady, smelled of alcohol, red, watery eyes. The officer observed the damage to the vehicle and had already known, because of the neighbor's report, had known about the clipping of these parked cars, both of them, and determined that the physical therapist was under the influence and arrested her. So as an attorney, I'll stop here and say, well, are there grounds to arrest someone who may be intoxicated in their own home when there was no observation perhaps of the actual driving itself? And so we would ask the question, is the neighbor's report enough? And can they identify the car? Perhaps. They could identify the license plate number. Perhaps. Could they identify who was driving that car? So there's a criminal side to this as well, a DUI side to this that might come into play, or it certainly is an issue that should be asked. So she was arrested. and taken to the station where she voluntarily agreed to a breathalyzer that showed a 0.19 at 8:24 p.m. and a 0.20 at 8:28 p.m. These officers took it on multiple occasions. Again, it was voluntarily agreed to by the physical therapist. Eventually, based upon these high showings, based upon the damage, and based upon the witness, the physical therapist was criminally charged and eventually pled guilty to misdemeanor hit and run, and the alcohol-related charges were now dropped based upon this negotiated misdemeanor guilty plea. So I'll stop there for a second and allow us to digest now what just happened. And this happens all the time, by the way, where an individual charged with certain crimes may plead to lesser crimes, plead guilty to lesser crimes, and then sometimes perhaps more serious charges are either dropped to misdemeanors or reduced to misdemeanors or dropped entirely. And so as a regulatory board, now we all have to scratch our heads and say, now what? Okay, we have a criminal conviction of a misdemeanor. And so everybody on the line should now ask yourselves, are misdemeanor convictions relevant, no matter what they're for? Are they relevant to whether your board has the authority to step in and take an adverse action against that licensee? Or is it limited to felonies? Or is it limited to something? Is it specified to some other degree within the statute itself? So we can all now, again, back to the frustrations of the system, say, well, gee, the alcohol-related charges were dropped. That's a pretty important aspect of the factual pattern that we believe to have happened, and it's alleged, but that we, as the participants in today's call, and certainly in the case itself, believe to have had happened. So misdemeanor convictions, is that relevant to your world related to the licensee? So far, anybody want to either unmute or type in what you think the board should do from what you know right now? So perhaps is your statute so specific that maybe there's nothing you can do because it's a misdemeanor conviction? And if it's going to be premised only upon crime, the conviction, that's one thing. Does your board have the authority to step in and assess the alcohol facts of this particular matter, even though there was no criminal conviction related to driving under the influence? So do you independently have the authority to look at alcohol consumption, perhaps even addiction or other issues that might surface, and how might this play out? So be thinking about that. Somebody typed in here, treatment in lieu of conviction, and which happens as well. So I think the reference in this chat is these negotiated pleas where individuals may have charges either reduced or dropped, and they agree to certain kinds of treatment issues. And sometimes those are confidential. That does raise another issue, and what your board is able to find out versus not able to find out.
Dale, there is a sorry to interrupt. There is a clarifying question by Bob Frampton.
Oh, excellent. Let me scroll up. I think I scrolled
just above or treatment in lieu of conviction.
There we go. Did the initial incident take place in the delivery of care as a physical therapist? Okay, so a great point there now to say, thank you, Bob, and that is this related to practice, or did it take place in the delivery of care of a patient? Or is it an entirely social setting, and that perhaps then maybe your board either doesn't care because there's no criminal conviction on the DUI side? And then Bob goes on to say maybe only be a licensure issue if the DUI was an issue for the jurisdiction board, if the DWI is an issue for the jurisdiction board. And so I think what's being said there is if there is a DUI, does that fall within the grounds for discipline? Does it fall under the unprofessional conduct, ambiguous term, or others? And so a couple other comments here. From a board perspective, licensee is required to self-disclose the issue on relicensure. So what a great point right there is the self-disclosure on relicensure, or is it immediate upon when it happens? So let's say I've recently renewed my license and I have a 2-year period. I'm making this up, obviously, but let's say I have a 2-year period. Do I have to immediately report it? Do I wait 2 years and then report it? And so you all can be thinking about how that plays into your law. That should be actually specified within the law itself. And when I say law, that could be statute or regulations. But so that's self-reporting. What a great question. And it brings me all the way back to, do I have to self-report a misdemeanor? Do I have to self-report a felony? Do I have to self-report an arrest or others? And in much of the trainings that I do, when we do talk about criminal aspects of a matter, and I do relate that to how you phrase the questions on your applications for licensure and renewal, I would ask, if I were writing your applications from the ground up, have you ever been arrested, charged, convicted, pardoned, or expunged? So those 5 things are going to tell me everything perhaps that I need to know, at least to get this started and ensure that I make an informed decision as a regulatory board. Lawyers get a little antsy if I say I'm going to ask about pardons or expungements, and that's a debatable point. But since I have the microphone, I guess I get to say that out loud. But feel free to chat something in if you'd like there too. So we've got the self-reporting here within 30 days. It's got a self-reporting of arrests. Of convictions, not necessarily arrests. Arizona, 10 days to self-report being charged with a misdemeanor. And so Arizona, I'm assuming when I read that, then charges are enough, not convictions. So I have to at least tell the board I've been charged. And if I'm exonerated, I guess I would tell the board that later on down the road. Somebody saying we had somebody, I guess I can be a little more specific. So does that say Sherry? Sorry, it's really small print. We had a somewhat similar situation. Licensee got a DUI, self-reported as required, and then the board asked for paperwork once the licensee had met all the requirements. Okay, and so these are all now driven by DUIs, and now we know though that this individual in our fact pattern, the alcohol-related were all dropped. So these were just hit and runs, which I realize when I say it out loud, it sounds horrible. I mean, because everybody thinks a human being was injured in these hit and runs, but these are nicking these cars and then leaving. So I'm going to keep reading. Is it substantially related to the practice of the profession? Yes, substantially related is a good question. So we're going to get to that in just a minute. So let's just keep going. So, what should the board do? And my next slide is what did the board do? So let's get into that just a little bit. And some of the questions you're asking and some of your comments will start to surface. Some of the answers to these issues will start to surface. So the board served accusations upon the physical therapists, and the accusations included the following: a conviction of a crime related to the qualifications, functions, and duty of a physical therapist. So in California, the law is very specific about crimes related to the qualifications, functions, and duties of a physical therapist. And I know one of our earlier questions that came up, something on the lines of is it related to the practice or the patient? So you can see the California version is a bit broader than that, because it really just deals with qualifications, functions, and duties, which is quite a broad phrase to use. And do we know what that means? I'm not sure. And I do know that when I'm asked this question, is a crime related to the practice? That's a super difficult question to answer. Whether it's a DUI or if you took money from a trust or whatever it might be, is this related or not? Very difficult question, and it's hard to draft statutes that address those situations. Myself, I believe that the Practice Acts ought to be more ambiguous and just talk about convictions of the crime itself, and let the board ultimately determine whether that conviction is severe enough to merit an adverse action against the license in the administrative side. So we've got this qualifications, functions, and duties allegation. A violation of the Practice Act itself was the accusation, and then a violation of the Medical Practice Act in addition to the Physical Therapy Practice Act. And that is because the the Physical Therapy Practice Act references the Medical Practice Act as a basis for, if there's a violation of the Medical Practice Act, then it's a basis for grounds for disciplining a physical therapist. Eventually, a 4-day hearing was held. Everybody on the line, you all know that it went through its process of probably attempting to be negotiated, resolved, settlement agreements, consent agreements, whatever it might be. And they were unsuccessful, obviously, so they carried on to the hearing itself. I think everybody participating today understands that probably that doesn't happen a whole lot, and a vast majority of these cases are resolved through some kind of a consent or settlement agreement. So they did have a hearing now before the ALJ. So what do you all think the ALJ should do now under these circumstances? Somewhat of a similar question we've already asked, so feel free to type that in there. If you were the ALJ and all these facts surfaced, what would you do? And then what did the ALJ do? So in this particular case, the ALJ in a proposed decision, so in California at least, matters are heard before an ALJ, and I realize that many of your jurisdictions might have a little different nuance to how your adversarial formal hearings are held and then ultimately resolved. Here, then ALJ will make a proposed decision to the board. The board has the ultimate say as to what should happen. And then the licensee respondent has a chance to appeal, assuming they're unhappy with that outcome. So in the proposed decision by the ALJ determined the evidence did not support a finding that the physical therapist had an ongoing alcohol dependency problem. So that's a really, really difficult question now to deal with. Is one incident where all these things happened that we now know about, is that enough? And does that create a dependency issue? Or alternatively, is the incident at stake here all by itself, this potential single incident, is that enough? So the ALJ, had to grapple with that question. And then the second part, the second bullet there is, but the hit and run and the use of alcohol in a dangerous manner subjected the physical therapist to discipline. So that was the proposed, if you will, fact-finding decision. So far, thoughts and reactions, feel free to keep typing those in. I see a comment that came in when I was a board administrator. I was always told the board that there's a difference between a single DUI versus a pattern of behavior that indicates abuse. And that's a really good point. Do you have to wait for multiple DUIs? Is one enough? A really good question. And then our attorney gave us the same advice as apparently above there too. So continuing with your thoughts and continue to type those in. So the first comment came from FSBPT, a staff person, I assume. So far your thinking and your reactions are coming out. So let me go to the next slide. So the board now is confronted, if you will, or given this proposed decision, and it declined to adopt the ALJ's recommendations. And the board said the evidence suggested that the PT was impaired when she left her home. So let's stop there and pause for a minute now and say, well, in the criminal side, the alcohol-driven charges were all dropped. So now this board, the California board, is going to make a determination as to the condition of the physical therapist while driving, which is beyond what the criminal court established through its process. Nothing wrong with that happens. But again, this is a good issue for us to just pause on and say that. So, and ask these questions. So evidence suggests that the PT was impaired when she left home. So there's some conclusions being drawn that these hitting of these parked cars was an indicator of that. And the board concluded by clear and convincing evidence. So everybody on the line, you ought to know what the burden of proof is in your jurisdiction. It's either a preponderance of the evidence, which is more likely than not, or the balance of probabilities, or clear and convincing, which I'm not exactly sure how to define that. It's higher than a preponderance, but it's lower than a beyond a reasonable doubt criminal standard. So it's going to fall in there somewhere. You all ought to know what that answer is in your jurisdictions, and it will be the first sentence of every final order you enter. By a preponderance of the evidence, the board hereby finds the following. By clear and convincing evidence, the board hereby finds the following. So that you're telling the world you know what that standard is, that burden is. So it concluded by clear and convincing evidence that the physical therapist was under the influence and caused the accident. Okay. And that the cause did exist to discipline the PT under the Practice Act. And that the conviction of the crime, the hit and run crime without the alcohol, substantially related to her qualifications, functions, or duties as a physical therapist. So we're all now scratching our heads and saying, well, what are the qualifications, functions, and duties as a physical therapist? The board thought under all these circumstances, this was truly related. So what do you all think now? What about sanctions based upon everything we just talked about, based upon these findings of the board and the rejection, if you will, of the ALJ decision and the enhancement of the findings? What do you all think about sanctions of this? And if you think it should be none, you can type into the chats none, that perhaps this is not a basis for a board to step in. But so feel free to type those in as we continue to go and move on here about the sanctions itself. So here's what the board did. They revoked the physical therapy license, but stayed the revocation and placed the physical therapist on probation. So I always pause when I see these stayed revocations and ask, what that really means. And so if anybody wants to unmute and tell me what that means or try to type it in, I'm happy to read those out loud. These are really interesting approaches that boards sometimes take. So let me start first with defining, in my mind, revocation. And revocation is a removal of that credential, a removal of that license. And I am not a fan of revoking licenses unless it's permanent forever, because once you revoke that license, I can make a pretty strong argument that your board no longer has authority over that individual because their license is gone. It has now been revoked, removed, and it may divest your board of administrative jurisdiction. Whereas if I suspend a license for X years, subject to reinstatement, you as the board still have the authority to continue to regulate, if you will, that person. So revocation, interesting, word to use here, interesting sanction to mete out, but then a staying of the revocation and a probation. So I'm assuming that if there's a violation of the probation, then the revocation kicks back in again and the license is gone. But I'd still ask the same question I just asked about revocation. So people are asking about treatment issues and the probation. The probation, I believe, was for a 2-year period on this. And obviously that means this individual has to behave. So I'm scrolling up to make sure I didn't miss any other comments. So you've got a couple-year probation issue. Now, the board required a clinical diagnostic evaluation regarding substance abuse. Probably a pretty good move on the board's part, because they need to know from a professional if they're dealing with someone who has a substance abuse problem or if this was an isolated incident. And the board then also said that there will be no further alcohol-related provisions if the evaluation said there's no substance abuse. So now you're relying upon a professional to give you help, which is probably a good move. But now in the end here, you've got an individual who perhaps is able to continue to practice. And you guys think that's a good idea or perhaps not a good idea? So feel free to type that in as well. Oops, did I go the wrong way here? Okay, based upon that final order, here is now where we get back to our writ of mandamus, where the licensee filed a writ of mandamus asking the court, so this is like an appeal of the decision, to direct the board to set aside its decision and dismiss the accusations. And many arguments were made by the licensee in this, including the single incident. You need to have more than one incident. It's not related to the qualifications, functions, and duties and others, and that the board is just not correct in its decision making. And so in this, as I've mentioned, in this case, this is a writ of mandamus challenging a board adverse action. It could come in many other forms, and it may not be called mandamus in your jurisdiction. So what should the court do now? And what do you all think may have happened? So the Superior Court, this is the first level of appeal, determined that the misdemeanor hit and run was not sufficiently related to a physical therapist's qualifications, functions, or duties. And so here again, we can now scratch our heads and say, well, what are the qualifications and functions and duties? And not running into cars and leaving the scene of an accident, is that logical that it should be related to those qualifications, functions, or duties? Debatable point. And again, I don't want anyone to misinterpret my comments here and my editorial comments as to being unsympathetic to the situation. So I try to look at these as objectively as possible. So the Superior Court said not related to the qualifications, functions, or duties, but the evidence did support a finding that the physical therapist used alcohol in a dangerous manner. So this is where I found the case to be most interesting, because all those charges were dropped on the criminal side. So this was determined on an administrative proceeding. And by the way, there were expert witnesses that testified for both the board and the licensee, and all, and you can imagine whenever an expert testifies one issue, another expert will testify the opposite, and you guys as boards have to make ultimately those decisions. So the evidence did support that. They denied the writ of mandamus and upheld the board's ruling of a stayed revocation with a 2-year probation period and the alcohol evaluation. And the physical therapist then appealed this to the appellate court. So once again, I'm asking everybody, what do you guys think the appellate court did or should do? Let's keep going now. So the appellate court, by statute, determined that by statute, the legislature has determined that the use of alcohol, to the extent that it poses a danger, is related to the qualifications, functions, and duties as a physical therapist, whether it was on the job or not, whether it was one incident or multiple incidents, but it is related to the qualifications, functions, and duties. But you can see in there that the use of alcohol, to the extent that it poses a danger. So it's interesting, do boards make those types of decisions? Well, in this case, perhaps they do. And in many cases, perhaps they do. In most cases, you all wait for the criminal courts to do that work for you, so to speak. And then you enter the criminal conviction into the record and carry on. Obviously, in this case, that didn't happen. So the appellate court also said the statutes implicate the Medical Practice Act, and violations of the Medical Practice Act constitute grounds for discipline. And that was clearly stated in the Medical Practice Act. There is no need to establish multiple events. So one incident is enough. And there are multiple cases around the country dealing with this one incident versus multiple incidents, including a case out of Virginia. And I can't remember offhand what profession it was, but the letter S was added on to the word acts. So it was acts, plural. And the court eventually interpreted that S to say that doesn't really mean you have to have multiple acts. So that S did not come in all that important in the Virginia case. But here the court clearly is saying no need to establish multiple events. And probably most importantly, the court said there's no need to establish a nexus between the events and the actual practice itself, so that someone who is endangered, if you will, the public, drove intoxicated, bumped into some cars, left the scene, there's no nexus to the practice. And one of our earlier questions or comments that came up was that issue about, is it related to the practice? So the court did answer that question. And the Virginia case is a veterinary medicine case. Thank you. And I do remember that now. So thank you for that notice as well. So these multiple event issues, that you don't have to have multiple events, and you don't have to establish this nexus, are very important points. And I think powerful tools for boards to have, not abuse, but to have, in order to ultimately protect the public and do your jobs as regulators. So they affirmed the decision of the lower court. The sanctions stood. the stayed revocation and the evaluation that the physical therapist had to go through. So any questions so far about what we've had, or did this bring up any issues that are either that either need further explanation or that you want to share with us about your jurisdictions? Feel free to unmute or type in the chats. But we will keep going in our discussions here. Everybody good so far? So a couple other mandamus cases to I think bring up here, and these are really good examples, I think, of an attempt to use a mandamus proceeding to try to require a government entity, a regulatory board like yours, to take an action, or perhaps not, but most likely it's to take an action. And here a complainant is not entitled to the remedy under a writ of mandamus proceeding, meaning the complainant was unhappy with the decision of the board to not investigate a matter in this particular case. It's a 2004 case from Ohio. It's a medical board case, but the complainant was not happy and wanted to require the board to at least investigate the matter. And the court said that the complainant is not entitled to such rights and therefore not entitled to this mandamus proceeding. It's another indicator of the rights that may exist. And this is not an unusual outcome. It's actually a writ of mandamus case. So I brought it into play here in our discussions, but complainants regularly challenge what it is boards do, perhaps, or not do, like not investigate, or there's a light sanction and the complainant wants a heavier sanction. And complainants in the US basically have zero rights to challenge these types of administrative decisions. So a mandamus proceeding would not likely work in any of the jurisdictions. And then on the opposite side of this, a physician here, in this case, also an Ohio case, by the way, and also a medical board case, the physician was entitled to a remedy under a writ of mandamus proceeding related to open records request. And here the physician was asking for records held by the board related to applications for licensure and otherwise. And so the board refused to turn these applications over, and the court said, no, you can't refuse to because they are public records, but you as the board are entitled to redact certain information related to Social Security numbers and certain disabilities and other identifying factors that are not subject to public disclosure. But it's a great example of using that writ of mandamus to require the board to undertake some kind of an action. And in this case, it would have been turning over documents and records. So while it's a big fancy sounding term, mandamus, it really comes into play quite a bit, and it may be called something else, but it is a good indicator of where the courts are being asked to step in and oversee what it is the administrative board community, you guys, have done or perhaps not done as well. So we're a little bit ahead of time, but I do want to make sure we entertain any questions or anything else or comments that anybody might have. Usually I'm bumping up against the hour and talking away, and I have to hurry and finish. So I'm actually a little pleased that we've gotten I think, some good information out. You can see on the bottom there that somebody ought to seek a writ of mandamus compelling the return of this great speaker here. But anybody have any comments or questions about mandamus or this Walker case, which is, I think, a really fascinating case dealing with some very important issues as to the authority of a board. I will wrap it up at least by saying I prefer to see the boards have authority because I have faith that that authority will be exercised in a manner that is appropriate under a group decision-making dynamic. So, you got 7 people sitting around a table making some decisions. You got all the information in front of you, you're going to make that right decision. But if not, somebody might challenge it under a writ and say, hey, you made a mistake, or I'm entitled to relief, or I'm entitled to the court stepping in. So comments or questions? And you can feel free to unmute, or you might have a couple minutes of extra time on this, what day is today? Wednesday afternoon. Ruggie, seems a little bit quiet, so I will turn.
I know.
Have to turn it back to you, or
Yeah, I do have a comment because when I served on the board in Oregon, we are the opposite of nexus to practice. I know for a fact that we are obligated to make sure that there is a clear nexus to practice. So this case would have been completely dealt with differently in Oregon, where there has to be a compelling evidence of nexus to practice. So if this person was doing home health, there was no question the person would be disciplined. But I just wanted to make that comment. But other than that, here we go. We do have a reminder about completing the webinar evaluation, and the link is offered in the chat. So everyone, the 34 participants, please don't forget to provide your feedback. That is always very valuable so that we can hear your needs and so that Dale can address certain needs. Oh, there is a question from Rich. I'll let you read that, Dale.
yeah, I see that. How many times have I gone bungee jumping? Oh, well, that does bring up now that our picture we started with, and whoever put neither on there, you are correct. So that is not Rich. That is not me. And to answer your question, Rich, I have never been bungee jumping. I could jump out of an airplane, but I don't know if I could jump off of a bridge.
All righty. It doesn't look like we have any comments or questions. In fact, one person has left, and I think we're all good. Thank you very much, Dale. And to all, thank you for being here, and have a great afternoon.
Thank you, Dale.
Thank you, guys.